Welcome to the Tenant Law Podcast, where we talk about new, interesting, and/or important legal cases affecting New York City tenants. This weekly pod will be about 10 minutes long. First, we give you some background so you can have the context to understand the case we are discussing. Then we talk about the case itself, and finally, we explain why the case is important and give you our tenant takeaway. I am Michelle Itkowitz, and today's case is In Re Stall York Avenue Company, a fairly recent DHCR par decision. So let's start with our context. Rent-stabilized apartments each have a legal rent. That's the amount that the landlord cannot charge tenant more than. If landlord does charge tenant more than the legal rent, then landlord has committed an overcharge. And if a court or DHCR is the state agency that oversees rent stabilization. If a court or DHCR finds that a landlord has overcharged a tenant, then landlord must give the money back to the tenant. If a court or DHCR finds that the overcharge was willful, and they very often do, they almost always do, then landlord may be required to give the tenant 3 times the overcharge amount back. It's a punishment to prevent landlords from overcharging tenants. So let's do some math. If the legal rent is $2,000 a month for an apartment and landlord charges tenant $3,000 a month, then that's $1,000 a month too much. And after 1 year, landlord has overcharged tenant by $12,000 for the year. If that overcharge is found to be willful, then landlord owes tenant $36,000. So now, what happens if a rent-stabilized tenant sublets her apartment to a subtenant and tenant overcharges the subtenant? So in our example, let's say tenant is paying landlord $2,000 a month, and $2,000 a month is the legal rent, but the tenant is charging the subtenant $3,000 a month. Same result. After a year, the tenant owes the subtenant $12,000 in overcharges, and if DHCR or a court finds that tenant's overcharge of subtenant was willful, and again, that's very likely, then tenant actually owes subtenant $36,000. Okay, so now the stage is set. Let's get into today's case. Now let's get into today's case. Today's case is on appeal from DHCR to the courts, so we don't really know what's going to happen with this decision, but it raises some great questions. In today's case, a rent-stabilized tenant sublet her apartment to a subtenant for about 6 years and really overcharged her. Landlord collected the correct amount. Landlord only took the legal rent from the tenant, but the tenant overcharged the subtenant, and DHCR found that the tenant owed the subtenant over $70,000. Now, here's where it gets really interesting. The subtenant asked DHCR to hold not only the tenant, but also the landlord liable for the overcharge award based on the doctrine of illusory tenancy. That means that landlord had constructive knowledge of what was going on, that the wrong person was in the apartment, that something was up. And DHCR held here that landlord did indeed have constructive knowledge of the subtenancy. The subtenant lived there for 6 years, which is a long time. The tenant wasn't there at all. The subtenant received mail at the building. The subtenant interacted with building personnel. She did laundry in the building. She walked by the management office every day. DHCR held that it didn't matter that landlord wasn't directly in some kind of a scheme with the tenant to overcharge the subtenant, or that landlord didn't get any part of the overcharge. Landlord's constructive knowledge was enough to invoke this doctrine of illusory tenancy and hold landlord responsible for the overcharge award as well. So now, even though this case is on appeal, it leads to some really important tenant takeaways. First, housekeeping. This is not legal advice. I'm not your lawyer, but because I am a lawyer, this might be considered legal advertising. If it is legal advertising, it is terrible because I'm asking you not to contact me. This pod is not a commercial for me or for my law firm. This is simply the podcast that I always wanted to make. Email us with your questions. I might be answering listener questions on the pod, but not announcing your name. I'd just love to say what New York City neighborhood you're from. And please give us the highest rating you can, as many stars as you can, because that's how other New Yorkers find us. And it is time for the tenant takeaway. Tenant takeaway time. Okay, first, some tough love for our tenants today. If you're overcharging a subtenant in your rent stabilized apartment, you're hurting the subtenant. But more than that, you're hurting the entire city because that rent stabilized unit is supposed to be affordable housing and you're not supposed to be making a profit on it. It's not good. Also, you can lose your apartment over this because you're doing what is known as profiteering, and courts will evict for profiteering. Number two, I really feel that this is very widespread. So if you're a subtenant and you suspect that maybe the tenant you're renting from is rent stabilized, if your neighbors are rent stabilized, or if you just want to check on this, here's how you do it. You need to take proof of your identity and proof of your occupancy. So you could take your sublease and you go to the DHCR website. That's the New York State Division of Housing and Community Renewal. They have a records access page and you upload the proof of your identity and of your occupancy, and you can get a rent registration statement for the apartment. And if you see that the tenant that you're renting from is only paying the landlord $1,500 a month, but that tenant is charging you as subtenant $3,500 a month, then maybe that tenant, and who knows, maybe the landlord owes you some money. And by the way, neither the tenant nor the landlord will know that you made the request. Now, number three, on the issue of does the landlord owe you some money? I don't really know where this is going to go on appeal. If I had to guess, I would say that the decision might be tailored a little, but the trend does seem to be going in this direction. And if overcharged subtenants had access to the landlord to recoup an overcharge, that would be very good for the subtenants, because the problem here is, like in the case that we looked at today. So this subtenant has a $70,000 judgment against a tenant who hasn't been there for now way over 6 years. So in order to turn that judgment, which is, let's face it, is only a piece of paper, into real money, she has to find the tenant, she has to find the tenant's bank account or the tenant's assets. It's not so easy. So if that sub had access to the landlord, that would be better for the subtenant. But that brings us to takeaway number 4, which is that landlords are not going to like this or feel that this is fair because they're not doing the overcharge. Now they owe the money back. So a perhaps unintended consequence here is, if this is where we're going, landlords are going to be going after illegal subtenants a lot more readily because they're going to feel that they have to in the rent stabilized context to prevent themselves from this type of liability. So lots of stuff to think about here on this one. And there you have it. Remember, New York City, the law belongs to you, but your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I am Michelle Itkowitz, and this is the Tenant Law Podcast.